In the case of Munna Pandey versus State of Bihar, the Supreme Court has recently clarified the court's authority under Section 162 of the CrPC to scrutinize police statements and question witnesses in criminal proceedings. In the light of this case, let's discuss the concept given under Section 162 of CrPC. Section 162 of the CrPC states that no statement made by any person to a police officer during investigation, whether recorded or not, shall be used for any other purpose than that has been mentioned under the first proviso to Section 162. The first proviso to Section 162 of the CrPC states that when any witness whose statements have been reduced to writing by the police is called for prosecution in inquiry or trial, the accused, with the permission of the court, may contradict the witness in accordance of Section 145 Indian Evidence Act. Let's have a look at the facts of the case. The facts of the case revolved around the accused who was convicted and sentenced to death by the trial court for committing the heinous crime of raping and murdering a 10-year-old. Aggrieved by the decision of the trial court, the accused approached the High Court in appeal. His appeal in High Court was dismissed and his death sentence was confirmed. Aggrieved by the decision of the High Court, the accused approached Supreme Court in criminal appeal. This criminal appeal was presented before the bench of Justices B.R. Gavai, J.B. Pardiwala and Prashant Kumar Mishra. The pivotal issue that had emerged in this case was during the trial when there were glaring contradictions between the statements that were given to the police during the investigation and the testimony that was given to the court. The court emphasized that Section 162 of CrPC does not impede a court of its inherent powers to examine documents or engage witnesses in questioning, even when it occurs suo motu or on court's own initiative. The court also stated that although the proviso to Section 162 sets out limited purposes, but it also mentions ways in which an accused can contradict the witness on the basis of the previous statements given to the police. But it does not in any way take away the powers that have been given to the court to examine the documents for the ends of justice which the court thinks is necessary to examine, or engage the witness in questioning which will be necessary to elicit the truth. After analyzing the case, the court concluded that the defense had failed to adequately exploit the contradictions that occurred between the police statements and the oral testimony given by the witness. Consequently, the Supreme Court set aside the High Court's order and remitted the case back for reconsideration.